Good day, everyone. So I hope that you are going great today. So now we were on our last topic, which is the Article 128 of the Labor Code. So it says here that a law is only as strong as its enforcement, and rights are only as real as their protection. So as you can see, this article is very important since ito yung dito nagsimula lahat ng mga natakil natin from the previous article. Ito yung pinaka-root or pinaka-causes why ang si Dole kailangan niyang protektahan si workers and of course to ensure fairness to them as to the employers. So ibig sabihin ng sayings ko kanina, ng sayings na to that this topic is important. It means that even if that law exists on paper, may labor laws or labor code tayo na sinusunod, pero it won't really matter unless someone enforces them, and the workers' right won't be truly protected unless there is a system to ensure compliance. So that is why may DOLE tayo, or may power ang DOLE to protect the workers. So now we're going to talk about the Article 128 of the Labor Code and the RA 7730. So this topic, actually lahat naman ng topic will definitely we will learn or madadala natin siya the future. Now, let's start with the section A of this provision. Actually, guys, ang mga provision here in Article 128 is sobrang mahaba siya. But of course, I will explain it to you ng maayos na hindi masyadong mahaba para hindi rin tayo maboard when we watch this video. So, unang-una, sobrang mahaba yung provision section A, no? But, ang highlight dito na ibig sabihin is access to records on workplace. Unang-una, under Article 128, may authority si Secretary of the Labor, sa authorized representatives, katulad ng labor inspectors, na pumasok sa workplace o mag-conduct ng inspections anytime as long as may ongoing operations o may nagtatrabaho sa loob ng company or organization. So, alam naman natin na during the inspection, ang ginagawa nila is titingnan nila yung bawat copy ng records ng company, ng organization, like yung payroll records, and may interview din nagaganap sa mga employees, sa mga employers, at ang ginagawa nila is nag-i-investigate sila sa anumang fact or condition para malaman nila kung ang isang company organization is may violations ba that is against sa labor code or the labor laws. So bakit ganito yung purpose nila? Bakit they can conduct inspections anytime? Kasi for example, kapag may government shop, kapag sinabi ng Dolly na mag-inspect kami sa iyo, ganito. So kapag alam ng shop na yon or ng organization na may na-violate sila sa rights ng mga workers, pwede nilang matago yung mga records. So therefore, hindi yun malalaman ng DOLE. Kasi one of the purpose bakit nag-inspect, of course, para makita nila kung may mga violations. So kapag sinabihan nila yung isang company, so magpe-prepare sila. Kaya naman, in simpler terms, in this section, sinasabi lang na may full access si DOLE sa company records at premises kapag nag-inspect sila. Lahat ng mga ginagawa na isang company or organization, pwede nila yung tingnan o investigate. Again, anytime they can conduct an inspection or investigation sa isang company. Now, for this section, kung kanina sa section A, mahaba yung provision niya, mahaba yung mga terms na nakalagay, mas mahaba ditong si section B. Pero, ang ano lang dito, yung main topic na sinasabi sa section B is yung a power to issue compliance order. So, sinasabi here in section B, kahit pa may ibang provisions, si Articles 129 and 217, sinasabi ng Article 128, specifically section B, na kapag may existing employer or employee relationship, DOLE has the power to issue compliance order. So, ano pala itong compliance order? Meaning, for example, kung may violation silang nakita during an inspection nila sa isang company or an organization like underpayment, no safety devices, and unpaid benefits, pwedeng maglabas ng order ang Secretary of the Labor na for example, kung may unpaid benefits, sasabihin yun ng DOLE na kailangan ibigay yun ng employer ang narapat na para sa employees. So, kasama din dito ang power to issue ng rate of execution para siguradong ma-enforce ang order. Pero may exemption of course. Kung si employer ay contested siya sa findings, pag sabihin natin contested means opposed siya sa findings ni DOLE kasi may mga findings siya or mga documentary evidences na hindi nasama during an inspection, pwede niya itong i-assess differently. At kung gusto naman mag-appeal ng employer, pwede naman siya. Pero kapag may monetary award, required na mag-post ang employer ng cash or surety bond. So if you can still remember, ang purpose ng cash or a surety bond is not just for the benefit ni employer or ni direct employer or ni principal employer, but for the benefit din ni employees. So kung, for example, hindi nabayaran si employees ni employer, ang gagawin doon ni Dole is doon siya kukuha ng amount of money doon sa cash or surety bond na pinarecord niya kay employer. So, ang surety bond, it is equal to the amount ng award bago ma-perfect yung appeal. So, ibig sabihin, hindi pwedeng mag-appeal ng walang cash or surety bond kasi security yon para sa mga employees. Now for the section, sa section C, isa sa mga power authority ni Secretary de Labor o ni DOLE o mga authorized representatives niya is to order stoppage of work o suspension ng operations kung may grave and imminent danger sa health and safety ng mga employees o workers natin. So once mag-issue ng order na pa-stop yung work or there is a suspension ng operations sa work ng isang company, so within 24 hours dapat may hearing para malaman kung tuloy na bang matigil ang operations or i-continue na yung pagtatrabaho ng mga workers. So dito din, kapag napatunayan na may violation, may danger sa health and safety ng mga workers at nalaman na fault yun ng employer, kailangan nyo pa rin bayaran ang employees ng full wages nila habang nakastop yung operations. So kahit na hindi silang nagtatrabaho kasi nga temporarily na-stop yung operations, still need pa rin yung nababayaran ng employer, yung sweldo nila at that time. So protection siya sa mga workers na hindi din sila mawala ng sweldo o ng kita nila kahit na temporarily na-stop yung trabaho nila dahil sa negligence or sa fault ni employer. So kapag hindi fault ni employer, another na yun siya na usapan and another rule na yun siya na ma-apply for those violations. Pero hindi siya nasabi dito sa provision or specifically dito sa section C. Only sa fault lang ni employer. For this section, letter D, in this article 128, so this talks about the obstruction is illegal. So it is clearly stated here no, in the article 128 and the section D na illegal para sa kahit sinong tao or entity na harangan or patatagalin or gawing mo lang bisa yung mga orders ng Secretary of the Labor. For example, kung mag-issue ng compliance of order, itong si DOLE, hindi yun pwede ipawalang bisa lang ni company or ng organization. And additional information, bawal din sa mga inferior courts na mag-issue ng TRO. So ano itong TRO? Ito yung mga injunction para papigilan yung enforcement ng DOLE orders na ginawa under this article, specifically in this section. So, meaning, kapag may compliance of order, katulad ng sinabi ko kanina, stoppage of order, so pag-stop ng operations ng company kasi may danger sa health and safety ng mga employees, hindi agad-agad na pwedeng pupuntahan ni employer yung korte para patigilin ito. Like for example, kung contested siya sa findings, may tamang process naman dyan. Kaya nga diba lahat tayo may rights. So may rights din si employer na of course ma-hear yung side niya. Pero hindi niya pwedeng ipawalang visa yon or pupunta siya agad sa korte kasi may tamang process para dyan. So kailangan mo nang isundin o i-appeal sa tamang process sa DOLE. Hindi agad-agad na ipawalang visa o harangin o patatagalin yung mga orders na inisyu ni Secretary of the Labor. And finally, in this section, ito yung last na. So, this tackles about the record-keeping requirements. Alam ko na, alam niyo na din na one of the power or the order ni DOLE na ipapakip niyo ng records ang bawat company or organizations. So, mag-require sila, ang Secretary of the Labor, yung mga authorized representatives, si DOLE na ang employers ay mag-keep sila ng specific employment records para magamit siya sa inspection. So, ano itong mga record-keeping, mga employment records? Like for example, yung mga payroll, timekeeping records, contracts, safety logs, at iba bang needed para ma-assess kung sumusunod ba yung company sa labor code o sa labor laws. So bakit ganito yung purpose? Bakit need na mag-keep ng records ng isang employee? Kasi for example, kung nagreklamo ang isang employee sa sweldo niya, pwede naman natin titingnan yung records ng payroll records. So kaya napaka-efficient or napaka-importante ng mga pag-keep ng records sa mga specific employment records sa isang organization sa company kasi nagagamit talaga siya kapag may unang-una kapag may reklamo si employee sa atin and kapag nagagamit din siya during an inspection sa DOLE. So one of the purpose din nito is for transparency at para mas mabilis na enforcement. And now let's go to the comments and cases of this article or this provision. So the first topic that we will tackle is about the regional administration and enforcement of the labor laws. So makikita natin dito how those laws are applied, monitored, and protected in a real workplaces or in a real life situation. So this topic is important because kapag nagtatrabaho na tayo, makikita natin how the DOLE and its regional agencies make sure na safe, legal, at fair yung work environment natin in the future. And now, balikan lang din natin yung three main core responsibilities ng DOLE. Natakil na siya last sa mga coverage ng PhilLIM. So now, matatakil din natin siya. So, babalikan lang natin. So, unang-una, to promote a gainful employment. Sila yung unang-unang nagbibigay talaga ng mga jobs and opportunities sa mga workers, sa employees, o sa lahat ng tao na need ng trabaho. Nagkakanak sila ng job opportunities, training, and programs so people can work and develop their skills. And pangalawa, advancement of workers' welfare. So, ito pumapasok yung the welfare, the health and safe conditions of the workers like minimum wage, safety standards, benefits, yung working conditions na safety and healthy for the na nakabe-benefit si employees. And the third one or the last one is the industrial peace. Of course, they promote mga conflicts. Dapat minimake sure nila na the responsibilities or the relationship between the employer and employee is talagang may connection or talagang may relationship ang employee at saka si employer. So dito yung mediation, arbitration, and policy making para of course ma-protection ng si workers and as well as may fairness din sa mga employers. So dito magkakaroon ng labor management. Now, for this topic, meron ding regional offices si Dole. Kasi we all know naman, alam natin na hindi kayang i-manage ni Dole lahat. May inspections, kapag may complaints yung mga workers, employees. So, meron silang regional at provincial offices o mga agencies. So, itong mga regional provincial offices na to, sila yung they act as a frontliners. Meaning, sila yung unang pinupuntahan ng mga workers, ng employees kapag there is complaints, wage issues o mga safety problems and etc. Kung may 5 division si DOLE, regional offices, agencies, o provincial offices, unang-una is si administrative division. Ang ginagawa niya is siya yung nagbibigay ng budget, logistics, o mga office supplies, so lahat ng support. Meaning siya yung backbone ng buong office. Walang vegetation nangyayari or inspection kapag walang administrative support. Pangalawa is yung labor standards enforcement division. So, gamit ang administrative support, papasok si labor standards enforcement division. Meaning, siya yung gumagawa ng workplace inspections. Chine-check nila kung sumusunod ba ang employer sa minimum wage, benefits, safety rules, working conditions na check nila kung may protection ba ang employer sa mga workers niya. So kung may violation, sila rin yung gumagawa ng report at recommendations. From there, kung ang inspection or ang findings ng research sa conflict, halimbawa kung nagreklamo si workers or may dispute, dito papasok sa Industrial Relations Division. Si IR, siya yung nagme-mediate, nagkakonciliate at tumutulong sa employer at employees para ma-resolve yung conflict nila bago siya makarating sa NLRC. And we all know that si labor arbiter, siya di ba yung nag-resolve sa conflict ni employer and saka ni employee. So bago makarating doon sa NLRC, sinusolve muna yon ni Industrial Relations Division. After IR, dito naman papasok si Workers' Amelioration and Welfare Division. From the word itself, welfare. So sila yung nag-aalaga sa welfare ng workers. Halimbawa, kung may affected na workers during disputes, may kailangan sila ng assistance like DOLE programs, benefits, or wage subsidy, sila nag-i-ensure na may human aspect ang enforcement. And finally, the Employment Promotion Division connects everything to long-term solutions. Kung may workers na displaced dahil sa closure or violations, sila yung nag-provide ng employment facilitation, livelihood programs at mga job matching. So sila nag-provide ng job sa mga workers. So inaalay nila ang compliance sa goal na magkaroon ng more stable jobs. Now, let's go to the Department Order Number 5704, the Labor Standards Enforcement Framework. Kaya ito ginawa ng DOLE o ni Secretary of the Labor kasi may malaking problema sila. Kulang na kulang ang labor inspectors dito sa ating bansa. Kung mapansin natin, mas madami yung mga company or organization sa ating bansa kasi kung gugustuhin or 100% man ang gugustuhin ng DOLE na i-inspect nila lahat ng company or organization, kaya nga lang kulang sila ng labor inspectors, kaya ginawa nila itong Labor Standards Enforcement Framework na may 3 approaches. Ang unang approach is the self-assessment. So the self-assessment is a voluntary compliance method. So para to siya sa mga companies with 200 or more than workers. So mga unionized establishments that with CBE or sa mga malalaking company na may mga HR na sila na nag-manage sa mga employees. So paano ginagawa ang self-assessment isang company? So every year ang DOLE nagsisend sila ng checklist sa company. So yung company naman through a joint committee, employer at employee representatives, sila yung nag-check or gumagawa ng checklist. So i-check sila kung complain ba sila sa labor standards like benefits, yung OSH or yung working conditions nila. So after accomplishing those checklists, kailangan nilang ipasa yun sa DOLE within 5 days. So yung purpose ng self-assessment is to encourage yung employees na maging proactive sila, na maging malesen din yung burden ng mga labor inspectors kasi pwedeng yung mga employees or employer naman sa company yung gagawa ng pag-check nun. And then i-promote din yung partnership or yung relationship ng employer at ni employee and to create a culture of honesty and responsibility in a workplace. And the next approach is the inspection. So ito na yung si DOLE na mismo yung nag-inspect. Good siya sa mga workplace na may 10 to 199 workers. So yung priority nila, sila yung pupunta nag-inspect is yung mga company na may mga complaints sa kanila, yung mga employees nila, workplace na may mga hazards like yung mga construction sites, and establishments with women and children workers. So ito yung traditional na enforcement tool na kung saan si DOLE talaga yung nag-actual check ng documents, conditions, safety, and compliance. So again, it is a traditional method na si DOLE yung mismo pumunta sa mga company or organization na to. Now, for the last approach, it is the advisory services. So, good siya sa mga workplace, the less than 10 workers, o yung mga small business o yung BMBE. So, yung mga, for example, yung mga maliliit lang mga tindahan, so good siya sa advisory services. So, instead, na nag-i-inspect agad-agad itong si DOLE uses an advisory services. So, nag-provide sila ng guidance and technical assistance sa mga small business na to. So, bakit advisory services lang ang ginagawa ni DOLE sa mga small business? Kasi ang mga small business, lack sila ng resources and knowledge to comply, unlike sa mga malalaki ng mga company, na need talaga na sila mag-assess sa self nila or sa company or organization nila. So dito, ang goal ng advisory services ng DOLE sa mga small business is to help them grow, to improve productivity, and eventually to meet the labor standards na i-enforce nila sa mga protection sa mga workers and as well as sa mga employers. And another part of this topic is the delegation to the LGU. So, pwede din na i-authorize ng DOLE or ng Secretary of the Labor na mag-inspect din yung mga LGU para mas marami at mas mabilis yung pag-check ng establishments. So, dito, ma-expand to promote yung goal ng DOLE to inspect no, sa mga bawat establishments o sa bawat company. And of course, to ensure a faster response. Let's go to the scope and visitorial enforcement power under this article. So sinabi ko kanina sa introduction na malawak or malaki yung power ni DOLE when it comes to inspection. They can check anything na records sa company or sa organization. And also, anything na may kinalaman sa pag-enforce sa labor laws, tine-check nila yon. So this means, anything that helps to check compliance, pasok din siya sa power ni DOLE. And next that, walang limit na sa halaga ng money claims. Kung noon, under the Article 129, DOLE could only act sa money claims kung it is 5,000 below. Pero dahil it is strengthened by the RA 7730, natanggal na yung limit na yun. So ibig sabihin, kahit million pa yung claims, pwede na silang mag-issue ng compliance order. And this amendment overturns sa mga Supreme cases or rulings ni Abdates and Cervantes na dating nagsabing may limit yung DOLE sa money claims. Pero ngayon, in this article, it is clear na, no, na sabi natin na malawak na or malaki na yung power ni DOLE when it comes sa finding ng inspection. And most importantly, under this article, specifically sa Section P, sinasabi na the Secretary of the Labor, itong si DOLE, can issue compliance order to promote the labor standards. So meaning, no need for the workers to file a case first. Pero may condition dito, ang power nito is activated lamang siya kapag ang findings is galing siya sa mga DOLE inspectors or sa mga safety engineers. So, ibig sabihin, inspection-driven authority siya. Hindi siya basta-basta, basta kaya ang findings is galing ka inspectors, labor inspectors, or sa mga safety engineers natin. So now, before I proceed to my next topic or to my last topic, let me give you a question first. O may question muna ako sa inyo. So actually, this question is palagi na natin siyang na-encounter simula nung prelim pa lang natin. So my question is, who determines if there is an employer and employee relationship? So, ang situation ko dito is contested yung findings ni employer. So kapag ganitong contested yung findings niya, opposed siya sa findings ni DOLE, sino ba dapat yung may authority, a power na mag-determine if may employer and employee relationship ba? Is it the DOLE or si NLRC? And now, to answer the question kung sino ba dapat talagang na-determine if there is an employer and employee relationship, si DOLE or si NRC ba, so ma-determine natin yan with this case ni Bombo Radio Rolling. So ito yung case na naging turning point sa usapan kung sino ba dapat talaga yung mag-determine. So before tayo mag-proceed sa formal discussion with this, to my final topic or in this topic, so sinasabi that under the RA 7730, malawak or malaki na yung power ni DOLE. So sabi ng law, notwithstanding with Articles 129 and 217, meaning kahit may limitations noon, tinanggal na yun siya. So akalat natin tuloy na si DOLE na yung final sa lahat ng labor standards matters, including sa pag-determine if there is an employer and employee relationship, not until dumating yung case ng Bombo Radio case at doon na siya nagkaroon ng conflict. So, ganito ang nangyari sa People's Broadcasting under the Bombo Radio case. So, may mga radio broadcaster, yung mga anchors na to na nag-claim, sasabi sila na mga employee sila, others employer nila sa Bombo Radio. Pero itong si employer nila, si Bombo Radio, sabi niya na hindi naman kayo mga employees, mga talents lang kayo o mga independent contractors. So, dahil dito, kapag may mga complaints, ang mga employees, dito nagkakandak ng inspection si DOLE. So, during inspection, the inspector, si labor inspector, or si DOLE, sinabi niya na pabor siya sa side ng mga anchors na to. Sinabi niya na employee sila, hindi sila mga talent. So, therefore, kasi ganito yung findings ng DOLE, ginamit nila or di-issued a compliance order kay employer, kay Bombo Radio. Sinabi niya na kailangan niyang mag-pay ng labor standard benefits. Kasi kung regular mga employee sila, may of course, like, ano sila sa mga benefits na dapat na pupunta sa mga regular employees. Though mga contractual na mga employees naman, may mga benefits din sila pero hindi kagaya sa regular employees kasi yung mga contractor natin anytime pwede yun sila ma-dismiss ng mga principal employer. So dito, di ba sabi nga ni DOLE na mga employees sila, hindi sila mga talents. Dito na nagka-issue kasi sabi ni Bombo Radio ng employer na ang DOLE or DOLE hindi mo naman trabaho sabihin kung mga employees itong mga contractor na to nagtrabaho sa akin. Kasi yung trabaho na yun that should be for the NRRC or sa mga labor arbiter. So dito na nagkaroon ng contested findings. It means oppose sa findings itong employer. So now, sino ba dapat talaga yung nagde-determine if there is a employer and employee relationship? So, si DOLE ba or si NRC? So, ito yung rulings na ng Supreme Court under the Bombo Radio case. So, ito yung mga naging rulings ng Supreme Court under the case ng Bombo Radio in 2009. So, sabi ng Supreme Court, unang-una, the DOLE cannot make a final determination of employer-employee relationship. So, kahit malaki yung powers ng DOLE when it comes to inspection that is strengthened by the RA 7730, hindi kasama dun sa power nila o trabaho nila ang pag-decide ng employment relationship. Bakit? Kasi sabi ng Supreme Court, ang pag-determine ng employer and employee relationship, hindi siya bastang tanong lang. Complex siya, na need ng full evidences, hearings, and witnesses na hindi lang siya for a quick inspection lang. So, ito na yung answer kung sino ba dapat ang mag-determine. So, ang rulings ng Supreme Court is NLRC or the labor arbiter ang may tamang authority. May tamang authority to determine if there is a employer and employee relationship or sa employment relationship. Kasi ang mga labor arbiter o mga NLRC, sila yung quasi-judicial body, nag-handle sila ng mga evidences, nag-conduct sila ng hearings, and of course, they can resolve mga disputes. Kasi one of the rule ni labor arbiter is mga disputes, diba, ng employer at saka ng employee. So, medyo magaling na sila when it comes to pagde-decide sa employment relationships. So ganitong klaseng ginagawa ng labor arbiter, hindi naman to makakayang gawin ni Dolly. Kasi yung Dolly, nag-i-inspect lang sila yan. Usually, yung inspection ng trabaho nila, nag-check lang sila na mga authorized representative nila, yung mga labor inspector, that ang mangyayari sa inspection is 15 to 20 minutes lang. So sa pag-inspect nila, or during inspection, hindi naman nila ma-determine if may employer and employee relationship ba ang isang, for example, ang sa employment relationship ng employer at ni employer. And so, therefore, to answer your question, si NLRC talaga yung may authority, may power to decide if there is an employer and employee relationship. But si Justice Brion, hindi siya nag-agree sa majority, hindi siya nag-agree na dapat si NLRC. Si Justice Brion, magaling siya sa mga cases na to. So, hindi siya agree. Sabi niya, dapat yung Dolly pa rin daw. Kasi paano ma-enforce ng Dolly ang labor standards? So, kung sa pag-determine pa lang ng employment relationship is hindi na nila yon trabaho. So, para sa kanya, si Dolly pa rin should be able to determine if there is an employer-employee relationship when necessary para ma-implement yung Article 128. Kasi para nga sa kanya, malaki yung power ng Dolly when it comes to inspection. So, dapat, one of their rule then, or responsibilities, is to determine the employment relationship. Pero still, hindi pa rin, nagtanaig pa rin yung majority na ang labor arbiter o si NLRC yung mag-determine sa employment relationship kaysa kay Dolly. Kasi para nga kay Justice Brion, maging useless ang visitorial power ng Dolly kung hindi sila yung mag-determine. But still, yung NLRC pa rin yung mag-decide sa employment relationship.
Good day, everyone. I am Ashim M. Dimambao, and I am the second reporter of our group. So today, I will discuss the visitorial and enforcement power of Dolly Regional Directors under Article 128 of the Labor Code. The Supreme Court recognizes that Dolly Regional Directors have quasi-judicial power. Ibig sabihin po nito, pwede sila mag-inspect ng workplaces, alamin kung may employer and employee relationship, at mag-utos sa mga employers na bayaran ang kulang na sahod o benefits. In the Jethro Security case of 2009, the Supreme Court upheld Dolly's power to issue a writ of execution para ma-enforce ang unpaid claims. Sa Bombo Radio case naman po, noong una, nilimitahan ang power ng Dolly. Pero, noong 2012, sinabi ng Supreme Court na pwede talagang mag-determinate ang Dolly ng employer-employee relationship, especially during inspections. Ang desisyon nila ay subject only to judicial review, hindi sa NLRC. Ang power ng Dolly ay applicable lang kung existing pa ang employment. Kapag illegal dismissal ang issue, sa labor arbiter yon. Pero, pwede pa rin hawakan ng Dolly yung ibang violations tulad ng underpayment. Importante rin na ang Dolly can enforce all violations they see during inspections, hindi lang yung nireklamo. Finally, sa schools, kapag tumaas ang tuition, 70% dapat mapunta sa salaries and benefits ng teaching at non-teaching staff. Required ito kahit bumaba ang kita ng school dahil business risk nila yon. In summary, Dolly's visitorial and enforcement power strengthens labor justice by providing faster and more accessible remedies to workers without immediately going to court. It ensures better protection, especially for low-income employees who cannot afford long legal battles. And that will be all. Thank you.
Good day, everyone. So today I will discuss Case 6.3 on collective bargaining agreement salary increases and the key procedures for labor standard cases under Article 128 of the Labor Code. So these include sections 7.1 to 7.6 and an illustrative case involving COCOFID. So let's talk about the issue of this case. In private schools, when tuition fees increase, the law requires that 70% of the incremental proceeds, or IP, should be allocated to salaries, wages, and benefits of employees. So, in Central Scholar University, or CEU, there are actually two types of salary increases that existed. So first is the CBA negotiated salary increases. So this type of salary increase is funded by the university. And the second type is the integrated IP salary increase. So this type of salary naman is sourced from the employee's 70% share of incremental proceeds. So in case 6.3, the question was whether salary increases granted under a collective bargaining agreement can be charged to the 70% share of incremental tuition proceeds. So the union objected to the second type, yung second type na integrated IP salary increase, arguing that collective bargaining agreement increases should come from the university's fund, not from the 70% share. And the 70% share should be separate and intact. The Supreme Court ruled against the union and held that integrated IP is naturally part of the 70% share. Although it is integrated into salaries, its nature does not change. It remains an employee benefit sourced from their lawful share. So, integration of IP is legitimate. The purpose is to regularize and stabilize the employee's benefits. Instead of giving IP benefits irregularly, which is depending on tuition increases, integration ensures a steady and consistent salary component. And lastly, no violation of the collective bargaining agreement. So the university and union agreed to the integration during negotiations. Since IP is still used for the employee's benefits, it complies with the law. So let's take note that using the 70% IP share to fund integrated IP salary increases in the collective bargaining agreement is valid and legal. And now let's talk about the section 7 of this article, the disposition of labor standards cases. So labor standards refer to laws setting minimum conditions for employees such as minimum wage, hours of work, COLA, overtime, holiday pay, safety and health standards. So, Article 128 strengthens DOLE's authority through visitorial and enforcement powers. So, now let's talk about the due process on how to file for an inspection report. So, when a violation is reported, a Labor Standards and Welfare Officer or LSWO is sent to inspect the workplace. The officer must submit a report within 24 hours or within the time allowed by the regional director. So, ano nga ba yung contents ng report? So, it should contain specific violations found, recommendations for compliance, and exact computation of amounts owed to every affected worker. So, the purpose of this is to ensure quick action and prevent employer evasion, and also to create clear documentary proof of violations. So, ano nga ba yung coverage ng complaint inspection? So, even if workers complain about one issue, DOLE will inspect everything related to labor standards. So, this includes wage compliance, hours of work, benefits, records, and of course, safety and health issues. So this ensures that there are no violations hidden and all workers similarly situated benefit from the inspection. So, for example, if two workers complain about underpayment, DOLE checks if all employees are also underpaid. When violations are found, the employer can voluntarily correct them. So, there are actually two types of restitution. First type is the plant level restitution and the regional office restitution. So, let's talk about the plant level restitution. So, plant level restitution is done directly at the workplace and it is usually for simpler or smaller amounts. So, it must be it must be reported and verified by DOLE. And the second type, so, yung regional office restitution naman, it happens when the amount is larger or more complicated. So, this requires DOLE approval before it is finalized. So, bakit nga ba importante or required yung verification? Of course, it is to ensure correct computation, no manipulation, and all of affected workers receive their proper compensation. So as for the compromise agreement, parties, so when we say parties, ito yung employer and tsaka yung worker. So parties may settle the case voluntarily. So what are the requirements for this agreement? So the agreement should be in written form, signed before the regional director or authorized official, and of course, must not waive workers' rights before the legal minimum. So, may important rule sa compromise agreement. So, if the settlement gives worker far less than what the law requires, it is against public policy, not valid, and can be reversed by the Secretary of Labor. This protects workers from being pressured into unfair settlements. And lastly, the hearing process. So, if the employer fails to comply within 7 days or does not submit proof of compliance, DOLE conducts a summary investigation. So, ano nga ba yung nagtitrigger sa process na ito? So, it is triggered when access to the establishment is denied, records are hidden or not provided, and workers are not made available for interviews. So this ensures DOLE can enforce labor standards even when employers obstruct inspections. So let's talk about the Cocofid versus Trajano case. So what happens here is that workers complained of underpayment. And according to the inspection confirmed by the DOLE, there is actually underpayment of minimum wage, non-payment of ECOLA, and there is violations in 13th month pay. But according to the employer's defense, workers actually worked only for 4 to 6 hours and workers were allegedly piece rate earners. But according to the findings of the DOLE and the regional directors, payroll records showed workers were daily paid and not piece rate. So employer could not unilaterally downgrade employee classification to reduce pay, and this violates Article 100, yung prohibition on elimination or diminution of benefits. So, as the DOLE wage rules. So, the ruling of the Supreme Court is that no grave abuse of discretion by DOLE or the Secretary, and administrative agencies' findings are given great respect because of their technical expertise, and Cocofid's agreements had no basis in evidence. So, let's take note that employers cannot reduce wages or change employment classifications to evade compliance, and DOLE's technical findings carry strong weight in judicial review.